This is Democracy Watch. Marc, we don't often get really good news, but we've just gotten it here. Can you explain what just happened in court?
Yeah, so this is breaking news out of the state of North Carolina, where a federal district court has rejected the Republican effort to steal the state Supreme Court election from Allison Riggs. You may remember this was a very close election. Allison Riggs, the Democratic incumbent justice, won the election by just over 700 votes. There was a recount. There was a second recount, and Republicans launched an audacious plan to try to change the rules of what ballots get counted after the election was complete, tried to throw out more than 65,000 votes. This case sort of ping-ponged between the state courts and the federal courts and the State Board of Elections, and a federal district court judge just said that the federal Constitution prohibits, in his words, changing the rules of the game after it's over.
Marc, I got to ask because I think this is an important point. Who was the president who appointed the judge that was overseeing this case?
So Judge Myers, who's the chief judge of the district court, was appointed by Donald Trump in 2019. He is a very well-known conservative judge, but he was, not going to tolerate, in very, very clear terms, not going to tolerate this idea of gamesmanship where you vote first and then make the rules afterwards.
Is there anything that the judge said or that you can speak to more broadly about the fact that it even needed to get this far? I mean, this ruling really does reverse state court rulings, both at the hands of the North Carolina Supreme Court and the lower court in North Carolina, the appeals court, both of whom kind of sided, not in fully, but in large part with Jefferson Griffin, whose only goal here was to cherry pick out of 4 overwhelmingly Democratic counties a bunch of voters in an effort to erase Allison Riggs' margin of victory.
Yeah, look, so Brian, the whole issue in this case was always whether this was going to be resolved by the state courts or by the federal courts. I mean, the state courts in North Carolina at the trial court level, it's a fairly even bench, probably leans slightly Democratic. But once you get to the Court of Appeals, and certainly the state Supreme Court, it becomes a very Republican bench. And it is important for people to listen to this clearly. I'm not using the words Democrat and Republican as sort of proxies. I mean that in that they have partisan elections in North Carolina. And the North Carolina Supreme Court is a partisan court in literal terms, but also in the way in which they rule. It is a very, very partisan court. So Justice Riggs never, in my view, ever really stood a fair shake or a chance of winning in the state courts. And the question was always going to be, do the federal courts step in? Do the federal courts say, look, this involves the right to vote? And there is a lot of federal court precedent, including Supreme Court precedent, which this conservative judge cites, that says you don't get to do this. You don't get to change the rules of the game after the balloting is completed. And so, once it was clear that the federal courts were going to decide this, it was only a matter of time before we got a ruling from the district court. And then ultimately, this case could go to the Fourth Circuit. But I don't expect the Fourth Circuit to disturb this outcome.
So to be clear, Jefferson Griffin does still have the opportunity to appeal this, even though the playing field on which they have to battle this thing isn't exactly favorable to him.
Yeah, so here's the problem for the Republicans. It is not just that they came up with a theory that flies in the face of existing precedent. It is not just that they are trying to invalidate tens of thousands of lawful votes after the voting was completed, after the ballots had been counted, and only after he decided that he was down and needed to do this. But the Fourth Circuit is actually a very pro-voting court. I mean, this is the court that in 2013 struck down a North Carolina law for targeting African Americans with surgical precision. This is a Fourth Circuit that time and time again in 2020, when I was litigating to make sure the rules of voting would be fair in a pandemic, sided with the pro-voting side. It has a majority of its members have been appointed by Democratic presidents. There are a number of appointments from President Biden, a number of appointments from President Obama. So this is not a favorable terrain for Jefferson Griffin, particularly having lost before a district court judge who, is very conservative. Right. And so there's not a lot of runway left for him.
The part that frustrates me a lot is knowing that this is a case that was so egregious, even a Trump-appointed, very conservative judge in this federal district court shut it down as soon as it got into his courtroom. But nonetheless, there are still all of these judges in North Carolina, these state judges, both in the appeals court and the Supreme Court, who thought that this was an acceptable remedy to try and just cast off valid votes in deference to Jefferson Griffin, or to give him some method to be able to do that. And so I know this is kind of a futile question here, but is there some recourse knowing that we just have such overtly corrupt judges offering up rulings from the bench that didn't even carry weight among Trump-appointed federal court judges?
Look, I think anyone who reads this opinion will see not just the care with which the judge took these issues, but the annoyance and the outrage that this judge has about what has proceeded here. I mean, this reads like a lot of the opinions we saw also at that time from conservative judges after the 2020 election, where the judges could not believe what they were being asked to do. It is reminiscent, frankly, of some of what we're seeing in federal courts right now, where the Trump administration is coming in with outrageous positions. But let me give you a flavor for how this opinion ends. It ends with the federal judge ordering that the state board shall not, in all capitals, take any action in furtherance of the North Carolina Court of Appeals and Supreme Court orders. The state board shall certify the results of the election. Judge Griffin's motions for injunctive relief are denied. Judge Riggs' motion for injunctive relief are granted. The Vote Vet Action Fund parties, that's who my law firm represented, their motion for summary judgment is granted. The North Carolina Democratic Party's request for injunctive relief is granted. The Conley plaintiffs, another set of plaintiffs, request for permanent injunction is granted. I mean, like, the judge just down the line basically says that Griffin and the Republicans lost, everybody opposing them won, and that the state of North Carolina needs to ignore what the state courts have said and needs to certify this election.
Moving forward, Marc, we know that the North Carolina election board, the state election board, looks differently today than it did even just a couple of weeks ago. It is more Republican now by virtue of them adding another Republican member onto that board. Does that change things moving forward? Does that allow them to subvert the process that is playing out right now, either in this case or subsequent cases?
Yeah, so it's not going to give them any ability to do it in this case. I mean, in this case, a federal district court judge has issued an order that is binding on the state of North Carolina. He is applying the federal constitution, and there is simply no wiggle room. He has issued this injunction, and I read you part of it just to give you a sense. He is not leaving there any opportunity for the state of North Carolina to claim there is more process in their state courts or for their state board of elections to do anything. But you raise a really important issue, Brian. And it is a big issue for the future. And it's one that Democracy Docket has covered extensively, which is the change of how the state board of election is composed. It's not just that there is an additional Republican, but the state of North Carolina's legislature enacted a law that stripped the governor of the ability to appoint the majority of the state board of election and moved it to the state auditor. That's right, not the Secretary of State, who's also a Democrat, not the Attorney General, who's also a Democrat, but they found the one state officer who is a Republican, which happens to be the auditor. And so now the partisan Republican auditor appoints the members of this board, including a Republican majority. So going forward, when a lot of these issues are fought in the trenches of what guidance does the state board give, how are the forms printed, what are the counties being told to do or not to do, I worry about the future of free and fair elections in North Carolina. It's one of the reasons why my law firm and I are paying such close attention. It's part of the reason why we got involved representing the good nonpartisan plaintiffs we represented here, because these rules that get established in these states can have remarkable impacts down the line.
Marc, I got to ask, because in the event that that some of these upper courts would have handed down rulings that were preferable to the Republican candidate Jefferson Griffin, it would have established precedent that other Republicans in other states could have pointed to. Once you have precedent, you can say, okay, now in Texas, in Florida, in Michigan, wherever it is where Republicans are in control, they can say, well, we're also going to cherry pick a bunch of Democratic counties and challenge all of these votes and basically determine the winner of all of our elections that way. So does the fact that we got a resounding no from this case establish a different kind of precedent where now if Republicans try this in other states, in Florida, in Texas, wherever it may be, we can actually point to the precedent established here in North Carolina and make an affirmative case for them to be able to not do this?
Yes and no. So here is the good news. The good news is, yes, this is a precedent that will be cited in future cases. This will join a long list of cases that we regularly cite to say that what the Republicans' basic thesis is, their wish list, Donald Trump's playbook, is simply unconstitutional. So that's the good news, yes. The bad news, Brian, is they are hunting for their first win.
Yeah.
And they're still hunting for it.
Right.
And they only have to win one.
Right.
To be able to create this sense that the law is unsettled. And we always have to win. And so, when I talk about the fact that in 2020, we won 64 of 65 cases, and the one case we lost didn't really matter. It affected no votes, and it was in a Pennsylvania lower court. What I'm really saying is not, boy, look what great lawyers we were. What I'm really saying is we had to win everything. Otherwise, Donald Trump would be able to cherry pick, as you say, a precedent here to then argue someplace else. And then we had to do it again in 2022. We had to do it again in 2024. We've had to do it here in the post-election now here in North Carolina. And frankly, in cases that are still pending all around the country, including some arguments that Republicans have brought to the U.S. Supreme Court. And so it is a very, very fragile time for voting rights because the Republican theories are so extreme and so would so disorient and undermine democracy that they just have to win one of those cases, and we are in real trouble. And unfortunately, those of us on the side of litigating for the pro-democracy side, we have to win all of them just to add them to the list of precedent.
Well, look, I would say that there is nobody better situated to be able to do exactly that, to be able to bat 100% than you and your team. I would also ask, look, we've just talked about an entire case that really was at the forefront of our fight for democracy. We talked about an entire case where you and your team were pivotal in terms of litigating on the voters' behalf to make sure that their votes would be counted in this North Carolina race. So for everybody watching right now, I'm going to offer up something different. Usually we talk about Democracy Docket and still want you to support Democracy Docket, which is the news outlet Marc founded to focus on everything voting and elections. But Marc has a YouTube channel called Democracy Docket. I'm going to put the link right here on the screen and also in the post description of this video. If you are subscribed to this channel, if you're watching this video, click that button, make sure to hit the subscribe button and hit the bell so that you get all of the updates whenever Marc comes on and does videos of his own. This is important because we have to support this entire growing left of center progressive media ecosystem, and nobody is more deserving than Marc, who is fighting, on the front lines of all of these battles. So again, I'll put the link to his YouTube channel, Democracy Docket, right here on the screen, also in the post description of this video. Make sure to subscribe and make sure to support independent media. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.